It's going to come to finance.
All right, the state of affairs is that this is a joint hearing between Senate Finance and Senate Election Law and Municipal Affairs. I will call the Senate Finance Committee to order, and I will call the Election Law and Municipal Affairs Committee out of recess since we were meeting this morning and went into recess till 1 o'clock. And with that, we will have the prime sponsor introduce her bill, and we'll start moving right along.
Thank you very much, Mr. Chairman, and good afternoon to the Joint Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 297, which is relative to a pool risk management program. I would like to add that this bill was filed at the request of the Secretary of State. Senate Bill 297 has been introduced after I was made aware of financial and operational issues potentially challenging the solvency of some of the risk pools operating in New Hampshire. This information has given me great concern over the viability of some of those entities. Pooled risk management programs were authorized legislatively in 1987 to allow for political subdivisions to come together to self-insure coverage for their employees and municipal property, such as health, property, casualty, and workers' compensation. This bill will go a long way towards protecting the taxpayers, political subdivisions, and their active and retired employees through the addition of much-needed language to provide solvency and financial impairment protections for the pools, ensuring predictability and stability. The bill sets minimums and maximums for contingency reserve, ensuring the pool's success as an ongoing entity while making sure surpluses that are not needed are returned to the pool member political subdivision. This section will take effect in July of 2026. Further adds emergency trigger mechanisms that authorize the Secretary of State to seek a receiver through the court to enforce an immediate assessment of contributions to ensure financial stability and protect New Hampshire taxpayers, active and retired employees. The legislation also increases transparency through requiring disclaimer language for the self-insured coverage lines and states these pools are member-owned. Lastly, it adds 4 new definitions to key terminology that will ensure the efficient running of operations. And finally, this bill will take effect upon passage, except, as I stated before, the replenishment of the contingency firm reserves, which will take effect in July of 2026. Mr. Chairman, the Secretary, the Bureau of Securities, and Actuarial are here to answer any questions that you might have. And I thank you all for your time and your consideration this afternoon.
Are there any questions from the committees?
Thank you, Mr. Chairman. So as I understand it, this bill goes into effect July 1, 26, but the effect on contributions would not actually occur until fiscal year 28.
I just want to check and make sure. It says the effective date as amended by Section 3 of this act shall take effect July 1st, 2026. And Section 2 states the remainder of this act shall take effect upon passage.
I believe that the question about when
When
can
the
be
impact.
answered by the witnesses that are coming up.
Okay, thank you.
You're welcome.
Additional questions? Seeing none, thank you very much.
Thank you very much, Mr. Chairman.
Secretary of State? And remember, when I call somebody, if you have others with you, just have them come up at the same time. And you've got to share the microphone, but please introduce yourselves.
Thank you, Mr. Chairman. Members of the committee, I'm David Scanlon, Secretary of State. Next to me is Christine Ferraro, who is an attorney with Bernstein Insurer. And next to Christina is Hua Lee, who is an actuary with Casco in Washington, D.C. Yeah. And they're the experts that we rely on in these matters. At the risk of oversimplifying the situation, I do want to give just an explanation in simple terms of what risk pools are and Secretary of State's involvement with them. In RSA 5B6 in the law book, there's actually some annotations in the sections, and there was a court case back in 2004 that dealt with right to know information and a risk pool. And I think the explanation of what a risk pool is pretty good. So I'm just going to read this. It says, risk management pool for political subdivisions was a public body subject to the right to know law. The pool was a quasi-public entity governed entirely by public officials and employees, operated for the sole benefit of its constituent governmental entities and for the sole purpose of managing and providing health insurance benefits for public employees, managed money collected from governmental entities, and enjoyed the tax-exempt status of public entities, and performed the essential government function of providing insurance and pooled risk management programs to political subdivisions. That's it. In RSA 5B6, Roman numeral 1 says, any pooled risk management program meeting the standards required under this chapter is not an insurance company, reciprocal insurer, or insurer under the laws of the state, and administration of any activities of the plan shall not constitute during an insurance business for purposes of regulation or taxation. And then in 5B4 small dash a, it gives the Secretary of State the responsibility of oversight. And Roman numeral 2 and 3 in that section says the Secretary of State shall have all powers specifically granted or reasonably implied in order to perform the substantive responsibilities imposed by this chapter. For the purpose of any investigation, hearing, or proceeding under this chapter, the Secretary of State or any officer designated by him or her may administer oaths and affirmations, subpoena witnesses, compel their attendance, take evidence, and require the production of any books, papers, correspondence, memoranda, agreements, or other documents or records which the Secretary of State deems relevant or material to the inquiry. That's the statutory provisions that we are operating under. It is a role that is given to me by virtue of holding the position of Secretary of State. It is a role because of that I take seriously. And the importance of it is protecting the interests of the employees, both current and retired, taxpayers, and the political subdivisions themselves. Too often we see government failure when some event occurs that is pretty tragic and people are left pointing their fingers on who's responsible, what happened, how did we get in this mess. The reason for this bill, I'm disappointed to say, is that 2 of the risk pools are in danger of insolvency. It's that simple. They are not following actuarial advice. They're charging guaranteed maximum rates from members that are well below the actual cost of claims. They have prematurely liquidated financial investment instruments to cover cash flow. And they are hemorrhaging financially on a monthly basis. They don't want to be regulated. When I became Secretary of State, my instruction to the Bureau of Securities, who regulates and oversees investigations of the risk pools, was that we have had experiences in the past that have been adversarial. There was a lawsuit 10 years ago with a large pooled risk organization over large amounts of surplus funds that were being held by the pooled risk organizations. And after going all the way to the Supreme Court, it was determined that those surplus funds had to be returned back to the cities, the political subdivisions, and the taxpayers. As part of that, there was also a pooled risk organization that was known as PLT, that was part of a partner organization. The partner health pool was actually subsidizing the funding of the PLT organization. It was not solvent on its own, and that pooled risk organization currently is still in runoff until all of the debts of that pooled risk organization are paid off. So there have been issues in the past that have been pretty serious and dealt with. After I became Secretary of State and gave the instruction to my team that I wanted to have constructive, non-adversarial relations with these groups, we reached out and made that known. And then about a year after I became secretary, one of the pooled risk organizations came into my office and self-reported that they were having financial issues. We arranged a meeting with the pooled risk organization, with a team of individuals from my office, meeting with theirs, to try and start going through to see what the issue was and how it might be best resolved. I made sure that I attended that first meeting, and I expressed that same message that I just mentioned. Unfortunately, the executive director of that risk organization refused to come down and meet with me at the same time. Subsequent to that, we reached out to the board of directors. We actually brought Mr. Wali up to participate that and talk about the issues that we were seeing and that we were very concerned about. And he was cut off in the middle of his presentation because they were out of time. Whenever we have attempted to seek information, we often see stall tactics, there are delays, and there is freedom to use the pooled risk claims money to hire attorneys. And once legislation comes up, I'm sure you see plenty of lobbyists here in the room today. Again,
and to improve any impairment in financial status. This provides for what happens if there is financial impairment or there is insolvency. What are the certain steps that need to be taken? Written notification to members of a potential assessment, meaning that they have to pay more funds into the program in order to cover shortfalls. A written proposed course of action in order to remediate these deficiencies. And it gives the Secretary of State additional authority to issue an order to the governing board requiring abatement of a deficiency, for example, if a contingency reserve falls underneath the levels that are set in the law. It also gives the Secretary of State authority to order or to seek an order from the Superior Court or receivership if the governing board does not comply. This just gives the authority. That authority can be exercised as the Secretary of State determines based on the situation that he is faced. It provides for prompt assessment of participating members if required, and it makes sure that any shortfall can be recovered in a much quicker fashion, not over several years that further allow the financial instability to persist and to further put the members at risk. It set forth minimum and maximum ranges of contingency reserve. It depends on the lines of coverage that are involved, and Mr. Lee will get more into that. And finally, as we already discussed, it provides for a contingency reserve replenishment if the contingency reserve falls below minimum levels, and that's in the next. So I think, Senator, you had a question earlier. When the law comes into effect, and if this issue is needed, a contingency reserve replenishment, that will be in 2028. We believe that having the ability to assess ensures that the programs will not become insolvent and that all claims and expenses are fairly and equitably satisfied despite unforeseen events. It improves the financial deficiencies and also makes sure that the participating political subdivisions who have not paid enough into the program that is required are the ones who will make up the assessments and any replenishments, so that we don't have winners and losers, and we don't have members that didn't suffer the losses that need to still be paid for, subsidizing or paying for other members' losses. Make sure that it's equitable and on a pro rata basis onto the contributions that they paid before. I'm going to turn over to Mr. Lee. I can get much more detail, but I reiterate, we're happy to take questions on the language at any time.
Good afternoon, members of the committee. I'm here to speak today as an actuarial consultant that works with the regulator.
State your name, Mr. Lee.
Absolutely. It's Hua Lee. I work with actuarial consulting company Casco. Now, the Secretary of State and the Bureau of Security Regulation works with 5 different accredited actuaries on helping to regulate these pools, understand them. I'm the one that's selected to speak today because I'm accredited on both sides of the actuarial industry, both the health side as well as the property casualty side, so I can answer your questions on both sides. I see everyone has the package that I have prepared. The first page just provides some educational background on the significant differences between risk pools and insurance companies. I won't go into that. Feel free to read that at your leisure. The reason why I'm here and the bill is being proposed is that as has been mentioned, several of the pools have gotten themselves into financial difficulty, mainly due to years of intentionally charging less than the actuarially recommended contributions and replenishments. A secondary reason is the expenses that have gotten out of control, but the primary reason is year after year ignoring what the actuaries are telling them that they need to charge in contributions and replenishments. The first example of this is PLT. That pool is already in runoff and was forced into runoff because for many years they were intentionally charging significantly less than actuaries were recommended and being supported by an illegal subsidy. When that subsidy was forced to end, they were so far behind in their contributions and funding, they were forced to go into runoff. They could not recover from the years of intentional underfunding. The next pool I will discuss is Health Trust, and on page 2 it summarizes their contingency reserves over the years as a percentage of contributions. Health Trust has also, for years, intentionally charged less than actuarially recommended contributions. Their meeting minutes show at least 8 different instances and examples of them doing this, and that's just what we found so far. Examples include, coming out of the pandemic. So initially during the pandemic, people went to the doctors less, and health pools started making, well, all the health programs made a decent amount of money because people didn't go to the doctor, and they didn't have to. And then coming out of it, people started returning to the doctors, so health trust actuaries told them, you need to add a charge because it's likely people will start coming back and we might lose money. They did not do that. The minutes show they elected not to do that. Other examples are about 4 or 5 years ago, there was a study done for health trust showing, your high deductible plans are significantly underpriced compared to low deductible plans. You need to raise the pricing for these because your members are moving to the high deductible plans. I'm sure you've all either seen this or experienced it yourself. People are going to high deductibles. So if you don't correct this, you're going to lose money in the aggregate. They did not, they ignored this. and they've identified that there's been significant shift into the high deductible plans. So as I said, we found at least 8 examples of them repeatedly not charging the contributions or replenishments recommended by the actuary. The result of that, as you can see here, essentially, if you ignore the COVID period where everyone had up and downs, they will have lost money in 5 of the last 7 years. And they're on track to potentially end in their worst ever financial position. They're currently losing about $2.5 million per month. And that may accelerate towards the end of the year because their claims pattern is higher expenses at the end of the year. So it's been $2.5 million per month, but that could accelerate. At the end of the year, at the $2.5 million rate, without even assuming any acceleration, they're likely to be down to approximately 15 days remaining of cash and reserves. So this is a $500 million a year plan. They're expected to be, under conservative assumptions, down to maybe around 15 days of cash and reserves. So that's the first consequence of spending years and years cumulatively of not charging the actuarially recommended contributions. The other is, because they've been low for a few years now, in order to make up for these years and years of undercharging, they're having to collectively increase rates by about 40% over a period of 3 years. So the first year was over 15%, the second is 10%, the third, it's not been decided yet, but given that they're losing about $2.5 million a month, is likely to be another 10 to 15%. So that 40% over 3 years, that's more than double the industry-wide level of rate increases in healthcare. That is not driven by healthcare trends. And so what's happening is the members are paying now these 40% increase to make up for the years and years of deliberately charging less than the actuarially recommended contributions. On the next page, we have NHIT. This pool also does not charge actuarially recommended contributions, and we found out this morning they're not even having an actuary annually calculate their contributions. They're having an underwriter do it, which is not appropriate. The law, and correct me if I'm wrong, actually requires them to have an actuary calculate it, and they haven't been doing that. The couple of studies they have done by an actuary, they indicated that the funding was inadequate, significantly inadequate, and the actuarial study also indicated they need a lot more contingency reserve than they currently have. So you can see here, they're in an even worse position than Health Trust. As of the last financial statement they gave us, they are underwater, meaning they have more liabilities than assets. The contingency reserve is negative. Now, they informed us for the second half of 2023, they expect to, have a decent amount of net income because of their own patterns. I very much hope that's true, but as of right now, they're essentially underwater because of, again, years and years of not charging actuarially recommended contributions, or when the actuary told them you need a lot more contingency reserve, they did not do anything about that, and they did not replenish their contingency reserves. On the next page, we have Primex, which is the property casualty pool. That's why this scale is very different than health. Property casualty is inherently completely different to health. Up until a few years ago, Primex were, in good financial shape, pretty stable contingency reserves. When we reviewed their financial statements for the last 2 years that they provided to us, 22 and 23, we found that they were charging more than 10% a year less than the actuaries were recommending. Okay. This was due to a combination of, firstly, I feel like a broken record, intentionally making adjustments to charge less than the actuarially recommended rates. So for all of them, the reason they've been doing this, and they've stated this many times, is to compete for market share. Now, all of them have been doing this for years in order to fight, whether it's each other or anyone else, for market share. So Primex was a combination of intentionally charging less than the actuarially recommended rates and also a double counting of revenues. But the net result is charging 10% a year less than recommended. So as you can see in this chart, the solid blue is what's happened to their contingency reserves. It's dropped by half. They're in a much poorer position than it would be. Had they just charged the actuarially recommended rates in the last 2 years, they would be in a great position, perfectly fine. School care, I won't spend long on. They are the ones we have the least concern about. We don't see evidence of them, consistently charging less than the actuarially recommended rates. They had a poor year last year, but they're still in good shape. So as I mentioned, the primary reason for these pools getting in such poor financial shape is intentionally charging less than recommended to compete for market share. A secondary reason is that expenses have gotten fairly out of control. Health Trust, for example, their administrative expense ratio, which means the proportion of these taxpayer dollars they're spending on admin and compensation and staff, is almost double the expense ratio of school care. Okay? They should be lower than school care. Because they're more than double school care size, there should be economies of scale in terms of how many staff you need, but they're at almost double. This is due to a combination of, firstly, they do provide an extremely high level of Cadillac services for a health pool, but they also provide a lot of services that are very unusual and we've never seen before for a public risk pool. Some of these include providing IT services, legal and HR type services, corporate retreats, hiring lobbyists, scholarship funds, and numerous other services that are not normally provided, certainly not normally provided by a public risk pool. Now, they have 300 members. I'm sure many of their members really appreciate all of these services they provide, beyond just healthcare related. But I'm sure many of them do not need these services. They should be focusing on things like wellness programs. That is needed for a health plan. Similarly for Primex, risk management, wellness, they're needed. All of these other services you never really see in a public risk pool. For NHIT, in terms of expenses, their issue is their expenditure on reinsurance has ballooned from about 10% of their gross premium, which is the normal level for a pool this size and what would be recommended. It's ballooned to 22% of their contributions is being spent on reinsurance premiums. So that's about $10 million a year. After you factor back what they get from the reinsurers, they're losing about $3 million a year on average on reinsurance. The level they should be buying is less than half that. So they should be only buying, losing maybe around $1 million or $1.5 million per year on average. Had they just stuck to buying the right level of insurance, the normal level of insurance, they would not be in their current financial predicament. That, savings of $1.5 to $2 million per year over years and years, they would be in great financial shape now if they continue to, charge the premiums that they had. But they're wasting a lot of money on reinsurance there. For Primex, their administrative expense ratio has been climbing and is now at 30%. So for every dollar of contributions, 30% is going on administrative expense. That's now even higher than the average for commercial property and casualty insurers. The commercial average is 25%, and it's been falling. Primex is now at 30%, and it's been rising. And one of the entire reasons any of this exists, why the risk pools exist at all, is that they should have lower expenses than the commercial industry. There are many different costs that commercial insurers incur, such as taxes, agent fees, that these risk pools do not have to pay. So they should have lower expense than commercial insurers. The Association of Governmental Risk Pools estimates that risk pools should be able to save the members and the taxpayers about 10 to 20% compared to buying commercial insurance. That's why they exist in the first place. That's heavily diluted or not happening at all because of these very high expense ratios. We've even heard cases of the members being able to get cheaper rates, cheaper quotes when they go to the commercial market, and that should never happen. So finally, how does the law address these issues? So there's a couple of components to the law. The first is to address the short-term solvency issue. What it does is it allows for a couple of different types of assessments. One is that the pools can do themselves. It authorizes them explicitly that if an actuarial analysis by the pool indicates at any time that they're short on funds, that they need more money, they have the authority to go and assess the members. So that is for the pools to use themselves if they determine that's needed. If they do not do that, there's an explicit trigger equivalent to about half a month's worth of cash that if the pools are not going to assess themselves when it gets that close to insolvency, then the regulator, at their discretion, can institute an assessment with about 30 days notice to bring it back up to that half month. So the specific number is, you'll see there is 4% of annual payments, but that's the idea that if needed, the regulator can then force it to come at least back up to that amount if the pools won't assess themselves. So that's in the short term. That should essentially make it impossible to become insolvent. That's the goal of that. Right now, there is no safeguards written in the law against the insolvency situation, whereas this should essentially make it impossible for them to become insolvent. The other key feature of the law, of the Senate bill, is more of a long-term feature, and that is the corridor, the minimum and maximum surplus. What that is designed to do is, over the longer term, prevent them from ever getting back in this situation again. So we don't have to, again, talk about what happens if they're insolvent, what do we do? Well, that's more of a long-term solution. As Ms. Ferrari said, that will become effective in terms of actually impacting contributions in 2028. They'll be measured at the end of 26. Any shortfall compared to the minimum will happen in 28. So over the long term, it keeps them, with that window of 2 years, it keeps them within that range. That not only will protect the long-term solvency and prevent them getting here again, that will significantly increase the incentive to charge the actuarially recommended rates. If they continue what they're doing and not charge actuarially recommended rates, they'll dip below the range, and then they'll be forced to tack on that replenishment. It is a 1-year delay, but no one's going to want to tack on replenishments if they don't have to. So it really significantly increases the incentive to charge the actuarially recommended rates. And that, in turn, in addition to protecting solvency, will create a significant incentive to start managing their expenses. Okay? If they have to charge what the actuary recommends all the time, cover whatever expenses they have, whether the expenses are reasonable or not, then it will really start to give them an incentive to reduce expenses. If they're going to insist on fighting tooth and nail for market share, what you want them to do is compete on things like lowering expenses, compete on providing value services. That's not what they're doing right now. They're competing by trying to undercut what they should be charging and outlast each other. Or they're competing by, rather than cutting expenses, pools like health trusts are cutting services. They're cutting what drugs are covered. They're cutting coverage for things like Wegovy and Ozempic. They're cutting programs that are designed to help members find cheaper coverage. They're doing everything but cutting expenses. So forcing them to charge the actuarially recommended rates will give them an incentive to finally do that. The next thing is actually in response to a question that some of the senators have asked to help quantify what is the impact of this law change. So as you can see on page 7, we've estimated the impact over the first 3 years of this corridor, the minimum maximum, for each pool individually. So the 2028 window is selected, that delay, to give people a chance to prepare for this law change. To, if needed, adjust their contributions. Health trusts currently already essentially do what this law is saying. This law is saying if your contributions are too low, you need to add a replenishment. Health trusts are already doing that. They've called it the capital risk charge. It's a 5.3% charge that's added to their contributions to try and help them to recover. Okay? So if we assume that that's what their net income comes to through the next 3 years, because they've already doing that, and because we've intentionally delayed the implementation to give people time, you can see there's actually no projected impact on health trust contributions in 2028, the first year it's in place. In the second year, this law is projected to lower member contributions compared to without the law change. And the reason is that 5.3% that health trust is charging everyone every year to try and replenish, they're going to charge that up to a target that they've selected that is higher than the high end of this law. So right now, they're projected to charge that for around 5 years. Well, because the maximum of this law is slightly lower, that 5.3% charge is going to come off of their contributions sooner. So in 2029, they're actually going to have lower expected contributions due to this law change. For NHIT, if they, between now and law implementation, do nothing, essentially, they provided us an estimate of their remaining income of 2023. We intentionally wrote all the assumptions here so everyone can evaluate exactly what we've done here. But essentially, the projected impact on them in the first year is about a 5 or 6% charge to get back into the range. So that would be for 1 year only, maybe around a 5.5% charge to get back into the range, and then after that, there would not be a projected impact. Okay. Now, NHIT did inform the BSR that even without this law change, they're planning on doing something to start rebuilding their contributions. So, whilst they didn't provide any specifics, if we assume here that looks something like a 2.5% annual charge to replenish contributions, if they were going to start doing that anyway, then the impact of this law change is expected to be less than 1% on the first year that it comes into effect. For Primex, based on their projected income for the next few years and the implementation window here, they're essentially projected to be pretty much back up to the range that the law suggested by the time this 2028 implementation comes in. So you can see there the assumptions we have them at 29.5%, which would be a 0.5% charge, but really they're pretty much expected to already be there so that under those projections, the law would have a minimal impact on them. And then school care, again, if anyone has questions about the specific assumptions we've used to project these impacts, please forward the questions to the BSR. I'll be happy to answer through them. But under a 2% per year net income assumption, they're projected to be comfortably within this 12 to 16% range that the law specifies, so that the law would not have any impact on them upon implementation. I do want to point out that the ranges here are before the amendment that has been suggested to give the regulator the authority to increase the high end of the range. So, and this was implemented in response to some of the questions that the pools themselves had. So the regulator would have the authority for a health pool to increase the maximum from 16 to 18%, okay, if they can provide actuarial justification. And we already talked to pools, examples of what that actuarial justification would be. And then for property casualty, they could increase from 40% to 45% if they can provide the justification for that. Speaking to the pools, only one pool has expressed that they feel the maximum is significantly too low. And I do need to spend a minute talking about that because it's really quite an important topic. Health Trust expressed that they feel the top end of the range, either 16% as written or 18% if they could justify it, is too low. And they have said this to us before, that they need a large amount of contingency reserve, and this is entirely based on an actuarial analysis that was done by their independent actuaries, Milliman. This analysis, they use it over and over again as justification for why they need so much contingency reserve. Well, if you actually read the analysis that Milliman has actually performed, it is not in any way a standard industry analysis of the needed contingency reserve. If you read the details in the fine print, what Milliman performed for them was a highly specialized analysis to show how much contingency reserve they need to support intentional underpricing and under-replenishment for a period of up to 5 years. Okay. So normally when you perform an analysis of how much an actuary provides analysis, you assume the pools will roughly charge a recommended amount, and then you look at what's the chance of another pandemic? What's the chance of claims being way more than expected? What could go wrong that way? Milliman's study, it's not at all like that. It's specifically to allow them to intentionally under-replenish and undercharge for a period of up to 5 years. So, in the prior meetings, they've tried to characterize this as some sort of independent analysis, industry standard for what is needed in contingency reserves. And we've been telling them for years, over the last 2 years, we've sent 2 or 3 written communications with them explaining why that's not what this is. This is a specific study to allow you to intentionally underprice for up to 5 years. So if it's an industry standard, it's the industry standard for how to underprice a pool for up to 5 years, if you like. And so, if I sound frustrated, it's because we've been telling them for years, and in the meeting this morning, they repeatedly kept asking for us, but what about this independent actuarial study? What do you think about this? What do you think about this? Well, we've been telling them in writing for years now, this is not an analysis of needed contingency, so this is an analysis of what's needed to intentionally under-replenish and underfund. Okay. So in terms of my prepared remarks, that is the end unless there are any other questions.
Thank you. I just have one. Do any of your no impact assumptions include that there wouldn't be surplus return at the end of the year? that it would just stay and go into that contingency reserve?
So that is what the maximum is. So the reserve range, like I said, it's 12 to 16, or 18 if they apply for the increase. If at the end of the year, the actual contingency reserve is above that, they will return the money to members. And that's what they already do, but they have been, manipulating their own contingency reserve targets and ranges. And that is what this, will help put a stop to.
Senator Pearl?
Thank you, Mr. Chair. Thank you all for coming in. Mr. Lee, on 28th of February, Health Trust released a statement regarding this bill, Senate 297. Have you seen that statement?
Yes, I have.
Do you have a response that you'd like to offer to it? I mean, they make assumptions or claims that, that 297 is too narrow and too sufficiently low to project against potential adverse claims experience. I just thought if you could share with the committee your comments on their.
Absolutely. So we saw that, and we thought it was important enough that the last thing in our report, the last 4 pages, is actually an appendix providing a detailed response to that. I certainly won't read out the detailed response, but please, I encourage you to peruse that appendix at your leisure. I will touch on maybe the couple of most important points on that. Firstly, Health Trust has, in that statement, sent several warnings to their members about the impact of the reserve range. They're saying things like, and I quote, at any time, if you fall out of the reserve range, you could be assessed within 30 days. They appear to have completely misread the provisions of the actual Senate bill and confused the emergency 30-day assessment with the reserve range. As I explained to them, or explained to you, and as the regulator actually explained to both them and the other pools 2 days before this press release came out, the reserve range implementation window is the 12 to 24 months. At the end of a fiscal year, if you're short, a year later, you will then spend 1 year replenishing. So essentially, it's a 2-year replenishment. They have completely misunderstood that and forwarded that misunderstanding to their members. Secondly, the issue of the reserve range being too low, they're really talking mainly about the maximum. And as I mentioned, they repeatedly, anytime they talk about contingency reserve, they refer to this independent actuarial study done by Milliman, which, as I won't get into more, but as I've summarized, it's an analysis of how much contingency reserve they need to intentionally underprice if claims experience is significantly worse than expected for up to 5 years. So even before this law change came out, we told them repeatedly why this is not reasonable and it's dangerous because it encourages you to do the exact behavior that ended up here, intentionally undercharging year after year. So that was before the law proposed Senate bill. After the Senate bill, that analysis is not only unreasonable or dangerous, it's completely irrelevant. The 5 years of intentional, up to 5 years, that has no relevance anymore because the window will make you replenish back up to the 12% within 2 years. So any sort of assumption of spending 5 years under replenishing, that's simply not physically possible anymore under the new law. So their comment there is solely based on that independent actuarial analysis by Milliman, which is, like I said, previously unreasonable, now was also irrelevant. And then the final thing I'd like to mention is that the very last sentence in Health Trust's response is, and I don't want to misquote. The bill would require Health Trust to be undercapitalized. I'm not privy to what they tell their members, but are the members aware that they're losing $2.5 million a month and on track to end the year with maybe 15 days of cash and reserves? That is beyond undercapitalized. That's, I can't even describe a word to how undercapitalized that is. And what the law will actually do is 2 things. In the short term, immediately make it impossible to become insolvent, essentially. They're not far now. The law will allow either them, if they want, or the regulator, if need be, to replenish cash if things get any worse for them. So that will take insolvency off the table, so members don't have to worry about that. They're self-insured groups. They would end up on the hook for any sort of insolvency. So it would take that away in the short term. And in the long term, as I mentioned, it will help them from ever getting back in anything like this situation again.
Thank you.
Senator Bertzel.
Thank you, Mr. Chair. Thank you for taking my question. So do I hear you right that the municipalities and those that are covered may not know that all of this is going on?
We have found no evidence that they have told them of this. I'll leave it to the regulator to share their view on that.
In terms of what we have seen as contributing to the problem of their financial instability right now and the precarious position that they're in, is, you know, the reasons that have been proffered to the members thus far are wildly different than the reasons that the Secretary of State and the BSR have determined for these issues. You know, for example, high price prescription drugs being utilized more, the pandemic, things like that, greater claims, medical claims, high levels of claims. Those issues very well may be occurring and contributing to the problem, but the main drivers of the problems are really the way that they're doing their rating for the contributions, the money coming into the pools, and the ways that they're doing the reserves, as Mr. Lee expounded on. And so we have not seen that and those issues communicated to the members in that way, so they can understand that those are causing the issues.
Oliver?
The reason I ask, I guess, is I received some information from Dave Karen, who's the town administrator in Derry, and he says, again, I'm unaware of any crisis which precipitated this legislation, so it sounds like they're not forwarding some of this information to the municipalities. Thank you.
That's been our experience.
Senator Waters.
Thank you, Mr. Chairman. I think this may be for Ms. Ferrari. On page 3 of the bill, I had a question about one section here. This is lines, the bold in lines 21 to 24. So I wondered if you could describe how this would happen. Do you anticipate, I mean, the folks who are still in the group would be set forth that they change their calculations and the contributions to be made. For the person who's out, who's left the group, is it a one-time payment? Would they have a year over? I mean, how would you get that money?
So I think you're referring to in RSA 5B5, let me just make sure I have it. Yeah. This specifically provides for if the contingency reserves fall below that minimum, it gives the ability to add to the next contributions, this replenishment that we've been talking about. So this makes clear in those lines that you referred to that the replenishment will not only be collected from the members who participated in the fiscal year for which the shortfall happened, if they continue on in the program, but also for those members who have left the program. So again, we get back to a situation where we have no winners and losers. We have those who incurred those losses and haven't paid enough, being the ones responsible for replenishing the deficiency in the reserve. And so the language here doesn't set forth a strict payment schedule, for example, but it does make clear that even if you've left the pool for the next fiscal year, like let's say in 2028, you won't be there anymore, you're still responsible because those losses or that deficiency occurred when you were a participating member. So it removes the incentive to leave a pool just to avoid something like this and then have that be put on the burden of the remaining members.
I understand. I just wondered if there was not something established as to a payment schedule and there's no rules around this, how you do it. Can I ask another follow-up question? I think this might be for Mr. Lee. On page 7 of your presentation to us, so I just want to make sure I understand this right, that you want to give people some time till 2028 to make the adjustments, and kind of that's an incentive, so they'll start doing something before then. Would it be my understanding of the bill that, let's say they didn't do anything and things got precarious, you'd still be able to step in?
Absolutely. So this is the only thing.
You need to move the mic in front of you.
I'm sorry. Thank you. Thank you. So absolutely. So this is the only thing that is delayed. The other assessments I spoke about, the ability for the pools to choose to themselves do the immediate assessment. If they don't do that, for the regulator to step in. Everything else in the bill is immediate upon passage. This is the one. So for example, if things got worse, both of those emergency assessments are available as soon as the bill passes. This is the only thing that's delayed.
There's one more, and this would be for Secretary Scanlon. And so, and I really appreciate that this is being addressed. It is really essential. I think it's, in a way, it's a little tough that this didn't come as a regular bill because we are in a hurry. It makes it harder to consult with the risk pools in the municipalities. I understand that, but it does lead me to the question of process. Do you think that there's any reason for the Bureau of Securities to have regulation, to have rulemaking, so that the kind of questions about how this might get done would have a rulemaking process, so that those things would get worked out with the municipalities and with the pools themselves, or what's your thought?
Rulemaking is certainly a possibility. I mean, it's not required in the statute, and historically, the Secretary of State's office has had very little responsibility for the rulemaking process. When we look at things like elections and corporations and final records, all of the procedures are just in the statute. But if it's helpful down the road to incorporate administrative rules, then it just needs to be written into the statute.
And if so it might be reasonable to think about that in this context for this Bureau.
Yeah, we can certainly think about that. Yeah.
Okay, thank you. Thank you, Mr. Chairman.
Okay, everybody else said their questions, my turn. The thing in the statement that caused me the most distress is the first paragraph, where they're talking about shifting responsibility for any liability from the towns to, I guess it's the company. I don't see anything in the bill or in the existing law that allows any of that liability to be shifted from the towns to anyone else. Am I wrong?
I'm sorry, Senator, when you mean shifting the liability, can you clarify in terms of the liability for payment?
If they were to become insolvent, and now we have a deficit, who is liable to make up that deficit?
Because of the nature of the programs being self-insured and the fact that only the members are public entities and political subdivisions and only the funding comes from public monies contributed by them, any unfunded losses such as claims, expenses, what have you, and other liabilities would fall to the political members at the end of the day. Whether that's through a workout process, a run-out process, receivership, if someone tried to seek bankruptcy protection, for example, at the end of the day, it would rest with the political subdivisions. And that's why the risk of insolvency or even a risk of sustained financial instability is so frightening because of that fact that the political subdivisions themselves would be bearing these.
But the political subdivisions, as I understand it, cannot file bankruptcy.
Well, I'm not a bankruptcy attorney, Senator, but my research does indicate that there may be situations where a municipality, which in the bankruptcy code encompasses all types of political subdivisions in New Hampshire, can try to petition for bankruptcy protection under Chapter 9. It's actually really a reorganization where they end up working out any unfunded liabilities and either raising funds or borrowing funds to support those. In order to qualify to seek such protection, there's a very fact-specific and multi-level test that has to be met. There's a lot of hurdles that need to be met. One of them is whether the municipality is authorized by statute in order to seek such protection, have such protection. Right now, New Hampshire does not specifically authorize that for municipalities. So while someone could try to seek such protection, it's not a foregone conclusion that the protection will be provided and that the political subdivisions will be able to avoid those liabilities that they have to pay.
PLT is the only one that we've had that has gone, but I understand that right now there may be a pot of money that is there that is paying the existing claims. And so we don't have a case that we can cite right now where a company has gone out of business, out, you know, whatever term you want to use, and had an outstanding liability. Is that true?
That's my understanding. We haven't seen that, and I think Mr. Lee was involved with the runoff as well and can speak more specifically to the PLT.
Thank you. So yes, fortunately for PLT, it looks like in their runoff they do have enough to cover the assets, so it will not be tested. But I want to make something really clear about what's certain and what's uncertain. You know, the legal, the lawyers, if you like, can discuss exactly how it would happen, but it's absolutely certain that any liability remaining in runoff will end up with the members. Whether it's, you know, somehow they're forced to give the money to what's left of the pool, or whether the pool just disappears and and then they just end up paying their own unpaid claims, the how, you know, hopefully you'll never have to figure it out, right? It's not been tested, but there's no doubt at all that it will end up with these pools. Now, this is not commercial insurance. There's no insolvency funds or regulatory rules helping. It will always end up with the members. And these pools, they're aware of this. So, you know, health trusts, when they almost lost their tax exemption several years back, the way that they were able to hold on to that was by, you know, writing to the IRS insisting that we are providing self-insurance to our members. We are not providing commercial insurance. We are not financially independent. We're affiliated with the members. This is self-insurance. So this is the whole premise for, you know, why they exist.
Senator Perkins Coca.
Yeah, thank you, Chair, and thank you guys for being here. So can you speak a little bit to where the 12 to 16% range comes from? And I noticed for Primex, it's 30 to 40%. I think one of the member questions, certainly from a constituent in my district, is just to kind of understand the data behind that. And then we see in the testimony of both the Health Trust and Primex CEO that they're sort of questioning that reserve level, which I think goes directly to sort of how these members address increased costs. So can you speak to that a little bit?
Absolutely. So the starting point for coming up with these thresholds is industry regulatory standards. You know, there's standards for public risk pools that we've looked at, for state insurance funds. The state of New Hampshire has their own health fund. So we looked at the industry levels, and something like, you know, a 10 to 12% minimum for health is quite common at the industry level. And then for property casualty, the magic number that most regulators tend to use is something like 33%. So that's the starting point for our thinking there. Then we specifically looked at individual pools, like what pools do you actually have? The actuarial analysis that they've both performed themselves. So, for example, we looked at Health Trust and NHIT's internal analysis. Siegel, the primary health consultant, did their own analysis, and then we tailored things. So, for example, for Primex, you know, we use the 33% as a standard because that really is the gold standard for regulating contingency reserves. And we selected a range that, you know, was in that range, but we think if you look at their history, other than the last 2 years where they were charging more than 10% less than recommended, they're really going to naturally stay within that range. You know, this is intended to prevent in the long term getting into financial trouble. We don't want people every year to be analyzing this. And then finally, the other thing we considered is, you know, well, two other things. Firstly, what is the likelihood that these will even be required? And we've selected them so that we think that if you charge the actuarially recommended rates, the likelihood of falling below the bottom, so, you know, charge recommended rates, it will keep you near the top. The likelihood of falling up below the bottom in a given year is 10% or less. So most years, this will not, the bottom of the range will not do anything. And then finally, we did think about, particularly on the health side, the confidence level analysis. That, you know, the intention is to make sure solvency is not possible. So for a pool, the NHIT size, this range, the maximum of about either 16 or 18%, is about a 98 to 99% confidence level. And that's based on their own independent actuaries' analysis. For Health Trust, we've only seen a 95% confidence level. So for 95, it would be 7%. And so this is well above 95, and it would actually end up being higher than NHIT because there's 10 times their size. So, for example, for Health Trust, the 16 to 18%, that might be something like 99 to 99.5% confidence level.
Senator Wonders.
Forgot to ask, but thank you, Mr. Chairman. This is for Mr. Lee again, kind of following up on that point. on Primex. Is there any upward pressure on what is considered the necessary contingency because of the increased losses over the last few years because of extreme weather events? Or, I mean, is that why I guess what I'm trying to say is the 40 more likely to be on the more safe side, given what we're seeing, the escalating costs for insurance?
That's a great question to answer. So firstly, you'll notice that the thresholds are not dollar thresholds, they're percentage thresholds, and they're percentage of contributions. So if the actuary is taking into account these trends, and I guarantee you every single actuary is, if there's one thing that would keep a property casualty actuary up, it's if you're doing property insurance, so we've been recommending 30% rate increases to our clients. That's less than some other firms. So other firms are more like 40, 50. So this is already being incorporated. And because this is a percentage, the actual needed contingency reserve is going to skyrocket when the contributions do. So firstly, long-term trends will actually absolutely be picked up by this. What you're worried about is in 1 year, the actuary could have way undershot, if you like. So firstly, that's why we want this minimum in the first place. Right now, there's nothing to prevent Primex from keeping, let's say, a 5% contingency reserve.
Yeah.
There's literally nothing. Now, with the 2-year delay, they're going to have to keep 30, if you like. If there's exceptional circumstances that would cause them to want to keep more than 40, like I said, they have the right to apply to have up to 45. If they came and, again, it has to be actuarially justified. If they say, we have real concerns about the adequacy of the pricing next year for this reason, can we please keep 45? That's up to the discretion of the regulation.
Thank you. And one of the reasons, Mr. Chairman, I ask is that I know that Standard & Poor and Moody's, starting a few years ago, have started to look at this issue in terms of the bond rating for municipalities. So it's better to be cautious. Thank you.
Okay, additional questions? Thank you guys very much. What I'm going to do is I'm going to take school care, then Primex, then Health Trust, and then NHIT. Then if the Commissioner of Insurance is still here at that point, we will take him and then get to the other people on the list. Okay? Yeah. But before I bring in the Commissioner, I do want to hear from the actual risk pool people. So who is here for school care? Anyone else with you?
My name is Lisa Duquette. I do have my Director of Finance with me, but I was going to be the only one speaking.
That's fine.
Thank you. Good afternoon, Chairman Gray and esteemed members of the Joint Committee. My name is Lisa Duquette, and I serve as the Executive Director for School Care. I've been serving in this capacity for the last 19 years, but I have an additional 10 years of public entity risk experience before working at School Care. School Care, as you know, provides health benefits to public sector employees, their dependents, and retirees, not only across New Hampshire, but throughout the U.S., especially for those retirees and dependent children to age 26. I submitted testimony yesterday afternoon. School Care's board met on Friday afternoon, and we are taking a neutral position on the bill. Our message to our members yesterday was that based on our internal analysis, that School Care is operating consistently with the terms that are in the proposed legislation, in the legislation that is on the table, as well as the proposed legislation. We did have a few comments regarding maybe some ambiguity in language, some clarifications, making sure that assessments are very different than replenishments, and that assessments would be a last resort. I also provided testimony regarding schools versus municipalities. School districts don't necessarily have the ability to pay unexpected assessments in a mid-year basis, but I'm imagining that all of you are very familiar with that. So given that, School Care is feeling fairly confident. We saw the packet that you saw, page 7, which shows the no impact. That reconfirmed that School Care is operating within the terms of the proposed legislation. And with that, I have no further comments. We believe that it will allow us to continue to maintain stability and predictability for our members. Thank you for your time, and I'm open to any questions.
And have you gotten a copy of the amendment?
I sure do have that as well.
Questions from the senators? All right, they're happy with you? All right, next one in the box is Primex.
Thank you, Mr. Chairman, and good afternoon to the members of the Joint Committee. My name is Ty Gagne, and I'm the Chief Executive Officer of Primex, a position I've held for 17 years, and I have 22 years total with experience with public entity pooling. Senate Bill 297, as introduced, raised concerns for Primex, and we were not going to be in a position to support the bill today. At the pools meeting last week with Senator Gray, Secretary Scanlon, and his team, we expressed concern that contingency reserve replenishments should have some flexibility, and that the administrative expenses should include the risk management services provided by pools. Late yesterday, we received amended Senate Bill 297, which upon review and analysis has addressed our two major concerns. We appreciate this. At a pools meeting today hosted by the Secretary of State's team, which included the actuary, we learned more about how contingency reserve replenishments would work under the amendment. And we learned about the projected impacts and timeliness to rebuild our contingency reserves. The impacts were not as significant as we expected, and amended Senate Bill 297 appears to contain adequate flexibility to address contingency reserve replenishment. Our pool covers risk that is different from the other pools. It's operational risk, and therefore we cannot speak to the health pool concerns. Primex, with respect to our programs, is willing to give amended Senate Bill 297 a try. We anticipate the Secretary of State and his team, under the language of the amendment, will work with us to accomplish contingency reserve replenishment if it is ever needed. We agree that pool solvency is very important and that our regulators should have appropriate tools to handle pool insolvency. In our attachments, there's an overview of Primex information, as well as information from our auditor and actuary concerning our strong financial strength. Despite our financial strength, we acknowledge that we do need to replenish our contingency reserve, and we will do so gradually within the parameters of the amended bill. You have your attachments that are included. That concludes my testimony, and I welcome any questions that you might have.
Questions from the senators? Thank you very much.
Thank you.
And now, Health Trust.
Good afternoon. My name is Scott DeRoche. I'm the Executive Director of Health Trust. I've been with the organization for about 13 years. With me is Gene Herrick, our General Counsel.
Scott? That's your name?
Yes, Scott
Did you
DeRoche.
sign in on the list?
I did, yes.
Okay.
Scott DeRoche.
Okay. Oh, there he is. Hey, I
Tried
almost
to
lost
get on bright and early.
Almost lost you. And you, all right, go ahead.
Okay, thank you. First, I must say that I very much appreciate the opportunity to testify. Thank you for your time. We must say that we do disagree with a number of the assertions that were made in the presentation previously. We had prepared written testimony that I believe should be before you. A number of the things that were said, I'm not sure if they were historic or if it's meant to be present, but we don't do certain things such as have scholarship programs today. We don't have a GMR today. We've not affected the drug coverage for Ozempic. So we're at a little bit of a loss for some of those statements. But in either case, we oppose this bill in its current form for numerous reasons and believe it is fatally flawed in substance. The bill unconstitutionally shifts the risk of losses from pooled risk management programs to the political subdivisions. Moreover, if passed, it would prevent health trusts from offering the medical coverage the public sector has come to rely on. Since 1987, New Hampshire's cities, towns, counties, and school districts have participated in pooled risk management programs established pursuant to RSA 5B. Access to pooled risk management is needed now as much as or more than it was in 1987. Under these pooled risk management programs, risk for medical, workers' compensation, property, and liability claims is transferred from the individual political subdivisions to the risk pool. If enacted, Senate Bill 297 will shift the risk from the pooled risk management programs to the cities, towns, counties, and school districts. This shift contradicts the very purpose underlying the enactment of RSA 5B and the intent of the law and would violate Part 1, Article 28A of the New Hampshire Constitution. Three core provisions in the proposed legislation are particularly concerning. One, the low maximum and narrow range allowed for contingency reserves held by the risk pools. Two, the new obligation for cities, towns, counties, and school districts to pay assessments within 30 days if the program becomes financially impaired or insolvent. And three, the narrow definition of expenses that may be retained and used for administration of the program. To help you understand these issues, I'd like to quickly provide some background information about Health Trust and its experience over the last 10 years. Health Trust provides a welfare and benefit program for New Hampshire cities, towns, counties, and school districts. We do not decline to quote any eligible political subdivision. We currently serve 191 municipalities, 6 counties, 85 school districts, and 74 other governmental entities such as water districts, libraries, and fire districts. These entities represent employers with very few employees to nearly 1,000 employees. Health Trust provides a range of plans so that New Hampshire public sector employers can find the one that best suits their needs. Over the last 10 years, both nationally and locally, healthcare affordability for employers and employees has become a major issue. During and after COVID, claims volatility spiked due to individuals first postponing and then later seeking care. These spikes further complicated the complex process of establishing renewal rates and highlighted the need for risk pools to maintain adequate capital. First, I'd like to explain the contingency reserve level, what it is, and why 12 to 16% is too low and too narrow. At the end of each fiscal year, Health Trust engages Milliman, a highly regarded actuarial firm, to perform an actuarial evaluation to assess the adequacy of contributions needed from participating groups and the reserves necessary to meet claims, expenses, and other projected needs of the plan. The amount needed for contingency reserves is included in this actuarial evaluation. In the materials that you've been provided, Health Trust refers to this as the capital adequacy reserve. An adequate contingency reserve is needed because Health Trust is a risk-bearing entity, very much like a health insurance company. A risk-bearing entity attempts to predict what will happen in the future, and its actuaries calculate contributions and reserves needed to cover expected claims and related expenses each year. But it also must plan for when things do not go as expected, such as when claims rebounded after COVID. The purpose of the contingency reserve is to ensure that if things don't go as expected, all future obligations for claims and expenses can be fully paid. When things go better than expected, Health Trust returns all surplus amounts above the contingency reserve level to participating groups. The proposed legislation would limit the amount of contingency reserve to 16% of contributions for the then current fiscal year. This is much too low. Current contributions are expected to be $470 million. For FY 2024, Milliman's actuaries recommended that Health Trust set a target contingency reserve between $95 million and $150 million. The minimum level calculated by Milliman, $95 million, is 20%. That's 4% higher than the maximum allowed under the bill, 2% higher than the maximum allowed under the amendment. In other words, the most Health Trust could retain under the bill is 4% lower than the minimum amount that Health Trust actuaries say is needed. At 16%, Health Trust would be undercapitalized by nearly $20 million. Second, I'll address our concern, which is that levying assessments on the political subdivisions participating in the program is unconstitutional and is an untenable shifting of risk of loss from the pooled risk management programs to the political subdivisions. To account for the risk that this undercapitalization presents, the bill would require that participating cities, towns, counties, and school districts pay an assessment within 30 days for certain shortfalls, which may occur at any time during the year. In effect, the bill would prohibit health trusts from maintaining adequate capital and then shift the burden of losses to the participating members. This shift not only contradicts the very purpose of RSA 5B, but it also assigns new responsibilities under RSA 5B to political subdivisions. This shift of responsibility likely violates Part 1, Article 28A of the New Hampshire Constitution. It also creates a massive challenge for our political subdivisions that often operate on limited budgets approved by voters each year. There is no need for statutory requirements that require pooled risk management programs to levy assessments on political subdivisions. Health Trust is a process for rebuilding capital that is in place and consistent with industry standards. Further, the statutory mandate in this bill that such assessments for unexpected losses be collected within 30 days of an event is untenable, as political subdivisions would not have the funds available to pay for such assessments. Third and finally, I'll briefly explain how the new definition will impact pooled risk management programs. The narrow definition of administration appears intended to significantly limit the type of expenses that may be retained by a program when determining how much surplus must be returned. Health Trust consistently outperforms the commercial market in part due to robust risk management programs. Rather than simply paying for claims, they actually reduce future claims exposure. For example, our well-being programs support healthy living, medical care access, expert medical support, disease management, and mental health care. The use of the word reasonable in the definition raises concerns that the Secretary of State's staff may dictate day-to-day operations in a way that would prevent Health Trust Board of Directors and executive team from carrying out its fiduciary duties. In sum, Health Trust follows actuarial standards that align with industry practice for like organizations. By forcing New Hampshire cities, towns, counties, and school districts to bear the risk of required undercapitalization, Senate Bill 297 threatens the very existence of the pooled risk management program that Health Trust offers and has served the vast majority of public sector employers well for over 40 years. If passed, this bill would limit coverage choices at a time when, due to recent claims experience, some political subdivisions are not even able to get a quote for medical coverage in the commercial market. Concludes my prepared remarks. Thank you.
Senator.
Thank you, Mr. Chair. Thank you for taking my question. So Mr. Lee told us that Health Trust was intentionally undercharging the contributions. So it would make sense then, if that's true, and not saying you're going to agree that, but that you would want a higher contingency reserve fund because you're not collecting enough to begin with, right? If you were to agree.
Yeah, so we hire actuaries for multiple different purposes. One of the primary purposes is determine recommended rates. And that has to do, that's the primary driver. It has to do with medical trend. What is the increase in utilization that's expected to be? What new medications are coming to market? Et cetera, et cetera. So we received that report. It's within the packet. There's both a rate letter for the July population and the January population. We do that every year. That information, those trend amounts, are what's used to build future rates. We also work with actuaries to have other recommendations come through and other analysis. So for example, the board of directors contracted with Milliman to do a relativity study to determine the relative value of the different plans. They did that and they presented several options, such as whether it's implemented over 1 year, 2 years, or 3 years, those relative plan changes. And so I can't speak to what artificial lowering of actuarially recommended rates, I don't know what that's referring to. My supposition is that it is actually one of those modelings, such as whether you implement something over 1 year or multiple years, that is being referred to. We have conducted for FY 2023 and FY 2024 actuarial analysis called a gain-loss report that's been provided to the regulator that explains the losses of those years, and it was not led in any way, shape, or form by undercharging of rates. It was very clearly a misestimation of trend that occurred. We had expected in some situations a trend of single digits, 8 or 9% as an example, and had a realized trend of over 20% on prescription drugs. So a significant trend is the major driving factor. We did not include the gain loss in the packet, but we do have copies available today that we could provide as well.
Could I follow?
Follow up?
Thank you. We received information from one of your members that Health Trust has, in addition to the issues that Mr. Lee brought up, discontinued some prescription drugs, which you said you haven't, but that also Health Trust had imposed funding caps on deductibles, altered retiree health plans, and eliminated some wellness programs. I'm speaking specifically of the Smart Shopper program, where there would be joint savings between the members and the trust. Can you speak to those?
Absolutely. So our board of directors, I believe very prudently, had directed me when I came into this position to do a review of the fiscal year 23 and fiscal year 24 losses. The starting point was that gain loss report that I just referenced. While trend and misestimation of trend were the primary drivers, there were some other opportunities that we had identified. So for example, some well-being programs that weren't able to prove out the return on investment. So we were paying a significant amount out in fees to the vendor, and we couldn't see the benefit back to the pool. There were other categories, little categories that were identified. One of them was that our medical plans, since their founding, have had an exclusion for anti-obesity medications. And we were found that we were still covering Wegovy and certain other anti-obesity specific medications. And so the board, in considering that through the summer at multiple meetings, discontinued or changed some of the program offerings and benefits that we have. So just to clarify earlier, Ozempic is by the FDA approval specifically for diabetic drugs. We do continue to cover that. Wegovy is primarily only approved for weight loss, so we did exclude those medications. Wegovy has now a secondary FDA approval for cardiovascular indications. Those are covered. And so the board did take action on a number of items to prudently manage and learn information from the FY23 and FY24 losses.
Another follow-up from
Yes.
Senator?
Oh,
Yes, just one more. And the funding caps and the altering retiree benefits, could you speak to those?
Yes, I apologize for missing that. I'll try to keep it all straight. So let me start with the funding caps. Health Trust did not have any exclusion on deductible funding by member organizations. We had left it up to the individual political subdivisions to decide in their collective bargaining agreements and things along those lines whether the employer would fund part of the deductible. We identified that that is a potential opportunity. One of the recommendations that we brought to the board in the same review of opportunities was a recommendation that they restrict deductible funding to 50% of the deductible or no more than 50% of the deductible. That's a common industry standard so as to ensure the plans are behaving as expected, because there's a certain level of consumerism that comes with the deductible. So that was a recommendation to the board. The board did adopt that, and so that will be going into effect with limited grandfathering for collective bargaining agreements that are in place. As far as the retiree coverage, our retiree benefits were self-insured products in line with our other medical coverage. We had specifically for those that were on Medicare, a Medicomp plan. It was a supplemental plan, and they were still on the direct commercial drug plan that we had intermingled with the other employees. The cost of that plan over time had become significant. It had become prohibitively expensive, depending on the political subdivision, that those individuals were with. And so we saw a number of individuals leaving our Medicomp plan with prescription drugs, moving to the Medicomp plan without prescription drugs, and going to obtain outside risk pools, a private Part D plan. And so coinciding with that, the Inflation Reduction Act was passed that put certain caps on Part D plans, that started to allow CMS to negotiate drug prices. There were a lot of opportunities there. And so we explored creating a EGWIP, so an employer group waiver Medicare Advantage plan. We were able to partner with Anthem to do so. That's a fully insured line of coverage. And so we did discontinue our Medicomp with prescription drugs in favor of the Medicare Advantage prescription drug plan. On average, that's about a 49% savings, equal to hundreds of dollars a month for the retirees. That took effect 1/1 of 25, and we've had exceptional support and positive praise from retirees through that process.
Senator Birdsall.
Thank you, Mr. Chair. Thank you for taking my question. So I heard you in your statement consistently talk about how the if there's a shortfall, it's going to fall down on the municipalities and the cities and towns. But public risk pools, risk is collectively retained by members, self-insurance done as a group. Who else would have to share the burden of the shortfalls, if there are any, except for the people that pay into it? When I was working at Raytheon, it's a self-funded organization, their healthcare, anytime their costs went up, we paid for it in our premiums.
Thank you for asking that question. So we are, for most of the lines of coverage that we offer, a self-funded risk pool. So we as an entity, Health Trust Inc., is self-funded, meaning we're carrying the risk. So Anthem, as an example, is a TPA on the medical side. We pay them a set administrative fee, but Anthem doesn't hold any risk. Health Trust Inc. holds the risk. So if there is a shortfall, we need to be able to cover it. That's why we are advocating for sufficient reserves, and we saw those reserves used in the post-COVID period, and we're now in a 3-year plan to rebuild those reserves. The relationship of a specific political subdivision with Health Trust is not self-insured. That's a fully insured relationship today. So that political subdivision doesn't have any obligation beyond paying their contribution rates today. So when there's a shortfall in a year, it doesn't go back to them. They don't have a $2 million claim and get sent a bill for $2 million in a true self-insured relationship. We used to have self-insured groups, a certain amount of them, no more than 3 at a given time. The last one canceled that coverage many years ago, School Administrative Unit number 60, that did have that risk to pay claims. But that's not an effective relationship for any but some of the largest of public sector entities. If you look at some of the large cities of Nashua as an example, they get to a certain size where it doesn't make sense to be with a risk pool. It makes sense to self-insure directly. So as a corporation, first, we do have other reserves beyond the contingency reserve. The other reserves are the IBNR or IBNP, so the incurred but not yet paid. It's referred to as a claims reserve. The administrative reserve, those are specifically actuarially calculated to handle a runout. So that if we were, as an example, to not offer coverage as of 6/30, all of those claims that were incurred would be paid. Those are fully funded and reflected on the financial statement that's provided. So they're for 2 different purposes, the 2 reserve categories. So if we did not offer coverage, first, the reserve would be there to handle the runout. That separate reserve would be there to handle the runout. At the end of the day, as a corporation, the members of the corporation would not be responsible for any shortfall there. Anthem would have paid the providers, as an example. Anthem would have a debt towed to it by Health Trust. Health Trust would have the reserves in place to handle a runout. And then if there were, by any chance, an amount left over at the end of the day, Anthem, as an example, would not be able to recover that from the political subdivision. That is very much why we feel that this is a policy shift of changing the risk from being borne by the risk pool to being borne by the individual political subdivisions.
Okay.
Senator Lang.
Thank you, and this may sound like a newbie question because it's a whole new topic for me. So we heard earlier, under current law, there is no requirement for the size of your risk pool. Is that correct? Your risk pool, your contingency
The
fund.
contingency reserves?
Yeah.
So we have a requirement to rely upon qualified actuaries. So we do every single year retain Milliman, one of the largest actuarial firms in the entire world, to do this study for us. They do issue us a report of a required capital adequacy reserve range. So we call it capital adequacy reserve. This bill calls it contingency reserve. It's one and the same. So they calculate, and you can see, because we included a copy of it in the written testimony, the methodology there. So they run stochastic modeling with the Monte Carlo simulation. So they effectively run a year 10,000 times with all different scenarios. Because in a normal year, everything would probably be fine. But you have once in 50-year events, once in 100-year events. What if there's a flu pandemic that runs through, et cetera, et cetera. So they run the year 10,000 times, and they say, what is the 95th percentile that over a 5-year period you would be solvent, meaning you'd have a contingency reserve above 0, right? And we look over a 5-year period because there is no backstop to us at all. So it's important that we have appropriate reserve levels. And so when they do that, the latest range that they developed is 95 million to 150 million. We included in the written testimony an exhibit of the last 10 years. You can see the minimum of the range has consistently been around 20 or 21%. The higher end is much higher than that. That's part of our concern with this band being too low. So we have a requirement to follow the actuary's advice. The actuary gives us that range of 95 to 150 million, and the board looks at that, discusses with the actuary, and determines where in that range they believe it would be appropriate to set the capital adequacy reserve target. Historically, they set it at the lowest end of that range. After fiscal year 23 and fiscal year 24, where we saw we did not have the pricing flexibility to fully recover within 1 year's time, the board this year set that target at $122.5 million.
One follow-up. So, but again, I guess my question is statutorily, not just looking at your company, but your industry, right,
Sure.
as a whole, right? Not everybody may follow your same plan or your same path. Statutorily, we have no guide rails. Is that accurate? Other than use an actuary's number and be able to justify it. Short of that, that's the only guideline we have.
Yeah, statutorily.
Hey, you haven't introduced yourself.
I'm sorry, Jean Herrick, General Counsel at Health Trust. Statutorily, we do have an obligation right now, and it is found under 5B5F. And 5B5F provides that the risk management program shall provide for an annual actuarial evaluation of the pooled risk management program. The evaluation shall assess the adequacy of contributions and contributions, I'm trying to read through, contributions required to fund any such program and the reserves necessary to be maintained to meet the expenses of all incurred but not reported claims and other projected needs of the plan. And so that's the guidance for us at this point in time.
So again, but it doesn't set a standard for anybody. It's whatever your actuarially says compared to anybody else's actuary. So if I go actuary shopping, I might get the one I want and get the results I want, or I might find somebody else's results that I like better. So my question is, I just want to be clear, my understanding is we have no state standard for what these risk pool contingency funds should look like.
You are correct. And we would be very supportive of reasonable standards. From our view, that has been part of this challenge over time, is there's not a rule that's out there. There is inconsistent views. We heard for the first time 3 hours ago how this 12 to 16% was developed. So we do very much support reasonable standards. there are reasonable standards that are available. NAIC, the National Association of Insurance Commissioners, has developed one. Our own insurance department has a reasonable standard based on RBCs with different threshold, between 2 to 3, here's what happens, et cetera, et cetera. So we very much are in support of reasonable standards.
Thank you.
Looks like it's my, oh, it's underwater.
Yeah, just
I'll hold
based
mine.
on,
I'll hold
thank
mine.
you, Mr. Chairman, based on Senator Lang's question, would it be fair to say, though, that if we set in statute actuarial standards, that over time, because of circumstances, the industry might say the actuarial standards actually have changed, and that what is in statute no longer reflects what is best practice?
So I'm sorry, Matt.
Yeah, would that be fair to say that that could happen?
That the standards may change over time?
Yeah.
I think that may. I think that would be an accurate statement, depending on, you're trying to project risk and your ability to cover risk, and nobody has a crystal ball. So depending on the risk that's present in the marketplace, I agree with you that that standard may need to change over time. The standard that's suggested in this bill, 12 to 16%, as I said, we believe is much too low, but it handles that risk by being able to, at any point in time, do an assessment to cover any shortfall. Whereas right now, we don't do an assessment. We don't believe that there is an ability or a liability to do an assessment. So we have to maintain the correct amount of reserves to be able to cover risk, and understanding that it's not just in a one-year time frame. So understanding the methodology first, understanding the exposure to risk, and then being able to choose the appropriate model and understanding that it may need to change depending on the risk that's present in the marketplace, it absolutely is something that changes.
Thank you. Thank you, Mr. Chairman.
Okay, my turn. What in the statute allows the risk pool to set up a corporation?
Take that.
Yep.
And if they did set up a corporation, and it's not in 5B, then they would be subject to the insurance regulations or other appropriate regulations, and that concerns me greatly.
So under RSA 5B5, it states that each pooled risk management program shall meet the following standards of organization and operation, and each program shall exist as a legal entity under the New Hampshire law.
Okay, and once you do that, if you were to use that and set up this corporation, how is that corporation protected from the other statutes like 240B or whatever it is for insurance? I mean, you can't have it both ways. You're either under the risk pool, or you're forming a corporation that's separate from the risk pool, and somehow taking the liability away from those who created the risk pool and are the managers of the insurance or of the corporation, and saying, okay, the corporation is because I said it is. You've got a lot of problems in this. So while you're thinking about that, okay, I want to say one other thing. If 20% is your problem, okay, I am more than willing to write chapter law that says for health trust, we'll make that limit 20% for 4 years, and it'll expire at that time. That would give you 4 years to prove that 20% is the right number for you and to have the statute updated. I mean, that's the big thing that I've heard, is that we're not giving you a high enough limit. So after the meeting that we had last, or I should say the Secretary of State had, I put in the provision that you would have a way to go back and ask for more. And if 20% is what you want, I'll give it to you. I'll put the bill in. And I can try and convince my fellow members of the committee, but I'll do it in chapter law. And I'll have that chapter law expire in 4 years.
If I may respond to your first point. I believe that we are operating squarely within what 5B5 permits with respect to Health Trust being incorporated. I'll pass the other question back to Scott.
Thank you. Very much appreciate that offer. As said, our actuaries repeatedly for 10 years, not us, not internal actuaries, our external have said that 20 to 21% is the minimum that can be maintained. We saw those reserves in action. We saw where we were at the minimum coming out of COVID years, and we returned $57 million back to the public sector over a 2-year period, only for 2 years later to be short $60 million, right? It would have been much cleaner to have that $3 million, but instead we returned 57, needed to raise 60. So we've seen that minimum of 20% in action and used, not hypothetically, to cover what were extremely robust rebound from the delayed COVID care. Primarily, though, it is very much a policy discussion. If we as an organization are bearing the risk with no backstop over a 5-year period where you'd want to maintain reasonable solvency, I believe that would be an appropriate level. If instead this is a shift to the political subdivisions constantly re-upping each year back to that minimum in a self-insured arrangement where each group is a self-insured group, then that would be a different standard entirely. So that's why from our perspective, this is very much a policy shift from what we believe 5B was intended and has been used for over 40 years to shifting this risk now to that political subdivision.
So what you've just said is you went from 20 to 21 now, okay? I'm still willing to go to 21, okay? At 21, are you willing to sign on to the bill and say, okay, I'm good to go?
At 21%.
For 4 years.
We would have, our actuaries would say that we would have a 95% chance of having a contingency reserve above $0 within 5 years at that level.
So you're willing to sign on to the bill? Is that going to make it? Is that going to get us to the end point?
I would need to review and model. I truly would. We received the text of this bill last Tuesday. I received details about it 3 hours ago. I would need to review and understand. We would love to collaborate with all the risk pools and with the Secretary of State on reasonable standards. We would love the opportunity to establish that.
And the risk of shifting funds or obligations back to the communities all depends on you not getting to, and the way the bill reads right now, it's 4%. Okay? And again, that's why I really am trying to get to a settlement here. All right? And I really am trying to give you an opportunity for either 4 years or if it's 5 years, whatever, to have your maximum, because you're the only one that's asked me for a higher one, set in chapter law. That's different than the regular statutes, for anyone out there that doesn't know, okay? But have it expiring at the end of that period of time where you would have to come in and say, okay, this is our experience, this is what we had to have, and this is now where the limit should be, and have that legislation come through. Are you ready?
I very much appreciate the opportunity and the willingness to discuss. I would say confidently that my concerns with this bill would be lessened with the 20% or 21%, as that's now within the range that our actuaries would predict. Being able to fully endorse, we would need to understand the industry standards that were used previously to get at what was stated as a 98 or 99% confidence interval over a 1-year period. There's a fundamental disagreement on the actuarial view, and it would be great to have the actuaries come together to understand the reasonable standards.
I do also understand that at 21% over those years, I would expect you to get to 21%. And that also means that your rates for your people who have joined your risk pool are going to be higher because you wanted to get that extra 4 to 5%.
Just to be clear, we are targeting a level higher than that now. We are within a 3 rating cycle rebuild plan, as was mentioned earlier, to get to the $122.5 million, which would be greater than the 20 or 21%. We are currently in a 5% additional charge for our July groups, moving to a 5.3% additional charge solely for the capital rebuild. So we understand that reserves need to be rebuilt. The board has adopted a plan to rebuild them. And you're correct, it does directly impact the rate that's being charged to our groups. And that is something we are comfortable with, and it's appropriate.
Saw a question. Oh,
Could I
Go ahead.
just add to that? I think that part of what Scott was also trying to get at is that we just got this bill Tuesday and have been reviewing it ourselves. We have had no time to review it with our actuaries. A flat percentage is not a number that an actuary would generally use in determining risk. And we would certainly want to review with our actuaries, given the current climate, because we are in a time where we have new drugs coming on the market. Vertex just was approved for a drug that will replace opioids. That is a drug that is fairly high priced for something that is taken multiple times a day. And if that was to catch on and there was a huge utilization and uptake on that, we don't know what that would happen with the claims that we get. So I don't think that we feel comfortable without talking with our actuaries, because that's the reason why the statute requires us to hire an actuary and to evaluate that risk, is that we understand the basics, but we are not trained as actuaries, and we certainly are not fellows of the American Society of Actuaries as our actuary is. So we really would have to take it back to our actuaries and see if within that 4-year time horizon you're talking about, whether 20 to 21%, whatever it would be something that would be reasonable based upon the information that they have.
I'm going to write the bill Friday afternoon, probably around 2 o'clock. Okay? That's when I'm going to write it. I saw a question over here.
So I think it's really interesting that you want to have at least 20% in reserve, and yet for the last 3 years, you haven't had more than 7% in reserve. So I guess it's a two-part question, is what were you waiting for? And two, when I look at the impact study that we were provided on page 7, given that 12 to 16% recommended rate corridor for, well, reserve corridor, you would actually be lowering your rates and returning nearly 3% to the subdivision. So I guess I don't understand your hesitancy on what's recommended currently in the bill as proposed.
Thank you for your question. So let me first say clearly that we are undercapitalized today. The 7% is not our target level. The 122.5 million is a target level. So we are undercapitalized today. The board has entered in a plan that was actuarially developed to achieve the target capital over 3 years. That savings that you referenced in the exhibit was simply because it identifies that the target would be hit sooner because it's a lower target in the 12 to 16% proposal. In our view, the reserves worked as they should in coming out of the COVID years. We had extraordinary claims expenses, and the reserves were able to pay for them. There was no claim unpaid. There was no backstop that's available or needed. So the reserves worked correctly to handle an unprecedented event. And so now we rebuild over a period of 3 years so as to be fully prepared in case another unprecedented event were to occur. The idea of getting there immediately within 1 year and then returning funds the next year, getting there immediately. It just increases volatility for the political subdivisions who are trying to forecast and budget. As stated, when the modeling is done by the actuaries, it looks at a wide variety of situations that would occur. Having an unprecedented trend of over 20% on the prescription renewal, I've never seen a prescription renewal like that. So it effectively guarded against that unexpected but possible extreme increase. And now it's a reasonable period of time to rebuild. So we are in favor of, and the board has proactively adopted the rebuild strategy, and we are fully in favor of having a reasonable standard for what should be held in contingency reserves.
Additional questions? Oh, Senator Lang,
Right,
I do
just a
have you on my list here.
comment to you, that's all. Again, I would not necessarily I would not probably support changing that to 20%, but I would consider on your amendment that we haven't discussed yet in section 4, changing that to that the company could come and request anything between a 1% and 5% increase based on the board's vote for that increase for the two categories. You have 5% and 2%.
Certainly, that would be a subject for executive session.
I'm just saying as an idea, I think that allowing each company flexibility without forcing companies up to a higher rate, I think would be.
As noted before, I would only be one vote.
Thank you.
Yeah, out of the many. Additional questions? Seeing none, thank you, and now we're NHIT.
Mr. Chair, esteemed committee, thank you for your time today. My name is Jeff Reardon. I'm from New Hampshire Interlocal Trust. I am here to oppose the bill today, but what I thought I'd do is give you a little bit of background about the trust and then some context around the reasons for our opposition. Interlocal Trust is the youngest of the pools. We started offering health plans to political subdivisions on July 1st, 2012, in partnership with Harvard Pilgrim Healthcare. And we, as all 5Bs, we provide those plans only to political subdivisions and only in New Hampshire. I currently report to a 9-member board. The majority of that board does hold some kind of public position. Our membership, not quite as impressive as some of the other pools, but our membership consists of 28 member groups. The makeup is 3 counties, 3 school districts, 1 public charter school, 18 towns, and 3 cities, with a total number of covered employees of 2,200 approximately. We partner with several professional firms to help us administer our pool, first being financial consultants that report directly to our board of trustees quarterly. We consult with actuaries, and they have multiple roles. They do our annual reporting for our risk tolerance or contingency reserve, our IBNR reserve, and our premium deficiency analysis. Our actuary actually also works with an internal underwriter that we have on staff to review and approve rates. There was a comment earlier that we use an underwriter. Yes, we do. We're blessed to have this person in-house with 35 years of experience underwriting health insurance, and she works closely with the actuary when determining rate recommendations. We also partner with the CPA firm who handles our audit every year, and they work with the administrative team, and they'll work with our finance consultants and to some degree the actuary to perform that audit every year. That audit is a public document. It gets submitted to the Secretary of State's office every year. And any of our members are welcome to it anytime they want, or any member of the public, really. So it's a little bit about New Hampshire Interlocal Trust. And then I just want to talk about our opposition. And I want to start by saying we're not opposed to new legislation. We're not opposed to new rules or defining existing rules. We just can't support this bill in its current form. First of all, we think that all stakeholders should be involved in that process. So to my knowledge, no political subdivisions, none of the pools, or other industry experts like AGRIP, the Association of Governmental Risk Pools, have been consulted in the drafting of this legislation. But we would welcome an opportunity to be a part of that process. And then the other reasons is we do believe that there are things in this bill that could be harmful to our members and really any political subdivision that's participating in a pool. Mandatory assessments. These entities don't have a mechanism to plan for a surprise bill in the middle of their fiscal year. And running and managing a budget is such an important part of their jobs. I think that creates more instability. Full replenishments. We are in a rebuild scenario because of the extreme situation with COVID. If we look just 5 years back, and where this isn't unique to us, but we saw a boon in our net position because claims were artificially low. But those claims did not go away. They were delayed, but because of the rules that we operate under, we ended up giving back. And for a pool our size, this is a lot of money, about $5.5 million for those 2 fiscal years. And the way those returns work is they don't go back till the next year. So those were for fiscal year 20 and 21, meaning they went back to our member groups in 21 and 22. That's directly followed by a surge in claims, but also underwriting and rating data being very skewed because we're using data that actually happened during the pandemic. So then what happened was the reserves that we had there were tapped into to cover that increase in costs. And now we're trying to recover from those losses. But I would argue that shows that those contingency reserves work. So a full replenishment anytime we're deficient, especially in a situation like us where we're very deficient, would mean extremely high rates for our member groups, where I think the appropriate and responsible approach would be to let's build up the reserves over time, which I do understand the regulatory body is in agreement with that. But what happens beyond that point, right? So we have taken action to build up our reserves over time, and we think that we'll get there in a period of about 3 to 5 years, maybe a little sooner if things go well from a claims perspective. The contingency reserve target of 12 to 16% we feel is a small target. I haven't had a chance to sit with our actuaries to get their opinion on where that target should be, so I can't speak to that. But either way, if that 4% target we feel is small, which to me suggests that it's possible that we might miss that target year after year after year, creating a situation where we're either going to have to be doing replenishments or returns of surplus in most years. And I believe this is going to create an environment of volatility. And that's the opposite of what our members want from us. What they're looking from us is to provide them with these health plans, provide them with excellent service, but most importantly, give us stability. And, you know, we're the new guys at the table here, but we have been able to do that consistently over the last 12 and a half years. So the last thing is that I do feel there's a lack of clarity on some of the points in the bill. I've read through it multiple times, and I just don't understand how all of the components work. So I think it would be nice, again, to work collaboratively and maybe better define some of these things, how the mechanisms work, when they have to be applied, and then really having time to digest all of this and try to determine really what is the long-term effect on our member groups. So I'm just going to wrap up by saying, again, not opposed to new legislation, not opposed to setting new rules and guidelines and better definitions of the different parts of the legislation, but I really think that it should be done in a collaborative way with the pools, more importantly, with the political subdivisions, and maybe other industry experts like folks from AGRIP. That is all I have for my prepared
Questions from the
remarks.
senators? I think we're good with you.
I like that. Okay, thank you very much for your time today. We really appreciate it.
Commissioner, I apologize for the delay, but I wanted to get those groups up and so that you could hear what they were saying.
Senator, no apology necessary. I'm a guest in your house. I appreciate it. For the record, DJ Betancourt, Commissioner of the New Hampshire Insurance Department, joined here at the table by Keith Nine, the Deputy Commissioner. Mr. Chairman, I'm going to share some thoughts with you, and then I do have another commitment, but Keith here will take the fire. He's smart. That's why I picked him to be the deputy. I'm here today because we strongly suspected that our department may be invoked a few times in the discussion, and not by any desire on my part to get involved in any more legislative items this particular session. We've got our hands full. But I did want to say that a lot of the concerns that we've heard here this afternoon are concerns that, from a consumer protection standpoint, the department shares. We have a commitment to ensuring the financial solvency and the financial health of the companies doing business in New Hampshire, because after all, it is incredibly hard for a company to pay claims to the consumer when it is insolvent or going bankrupt. So we certainly share that concern and commitment with the Secretary of State's office. I'll be the first to say I'm not intimately familiar with the dynamic that's going on over there right now. I'm hearing about some of these things for the first time, as are you. So I'm not here to pass judgment or comment on that. We have heard of rumors of financial challenges and things of that nature. Like a lot of other products that we don't regulate, people still come to my department because they see insurance or it looks like insurance, and so they come to us. So we're kind of familiar with some of the issues, but again, not intimately familiar with that. But with some of those issues that crop up from time to time that take on some real time and attention and heat, we do hear from the public, from some legislators, from some of the entities themselves, that they would prefer to be overseen by the insurance department. Whether or not you want to do that, that is a pure, straight-up policy decision. That is for you to make. I'm not here to ask for it. I'm not going to tell you by any means that we wouldn't do it. We certainly would if that is what you wanted us to do. But if in the course of your deliberations you decide to consider whether or not the insurance department's the better place to park this particular issue, what I would say is that we currently regulate 1,200 carriers that are doing business in the state of New Hampshire. That includes 60 domestic insurance companies. Within our department, we have a dedicated financial regulation unit. Those are all in-house employees. They comprise 6 analysts and 3 examiners, and then working with that unit are 3 actuaries, 2 in our property and casualty division and 1 in our life and health division. And again, they all work together The name of the game in terms of premiums, because I've heard some discussion about that, is to always ensure that the premiums are actuarially sound, which means that they are adequate to cover the claims that potentially could come in over the course of that year or whatever period of time that you are looking at. The pooled risk programs, as you've heard, there's 4 of them. And so adding 4 additional entities to the 1,200 that we currently oversee would not be a terribly big lift for the department. Again, those employees are all in-house. They would work with the actuaries that the entities retain or contract with, and we would go through the process of overseeing what the reserves are, what the premiums are set at, and all of the various other factors that go into determining whether or not the companies are financially where they should be. As was referenced by a previous individual who testified, the standards that we use are the standards adopted by the National Association of Insurance Commissioners. So that's an organization of all of the 50 state and how many territories, Keith? 6. I was going to 6 U.S. territories. We come together. The regulators come together. It's not just the commissioners that are involved with that by any means. It's the staffs of those departments as well. So they pool a lot of expertise. They pool a lot of intelligence and constantly review those financial standards to ensure that they are where they need to be. So long and short, policy decision for you to make. If ultimately you want to kick the tires on whether or not the insurance department is the right solution to this problem, those are the high-level facts that I wanted to give you. We do have that expertise, I believe. We would need an amendment to tweak the insurance statutes to account for these entities, and depending on exactly what you wanted us to do would dictate how that amendment or change to the statute would look like. But we want to be helpful, and so if you want us to take on that work, I think we would make it work if you felt that that was best. Keith, anything to add?
No, sir.
Introduce yourself, please.
Thank you very much. Keith Nye, Deputy Commissioner at the Insurance Department. Thank you for having me here today.
Questions from the senators? Senator Waters.
Thank you, Mr. Chairman, and thank you, Commissioner. So maybe you can't respond to this now, but seeing the parameters of this bill in terms of the contingency and then the methods that are included there for ordering certain things and so on and so forth, if this were to go to the insurance department, would it be appropriate for us legislatively to express such standards and operations?
So I'll be candid with you, Senator. I saw the bill for the first time about 20 minutes ago, 25 minutes ago. So I'm a little bit at a disadvantage, but what I would tell you is we would obviously take a look at what's proposed, contrast that to the standards and factors that we currently take into consideration, and make sure that it worked. And we would bring stakeholders together to make sure that, practically speaking, we understood exactly how it would work and that ultimately they could do it.
Thank you. Thank you, Mr. Chairman.
Senator Lang.
Thank you. So, and irrespective of the policy decision, who runs this thing, just again, do you think that establishing these contingency reserve corridors, as the senator called them, is good consumer protection for the consumer, which in this case is towns, cities, schools, to protect a company from going out of business?
What I always joke that the reason I went to law school is because I'm terrible at math.
Yeah.
So I rely on people who are much smarter than I am on that. But fundamentally, without a question, Senator, I mean, ensuring that the company has adequate reserves is a core part of whether or not I would consider a company to be financially healthy and to a degree financially solvent. Because the nature of insurance is that the risk is unpredictable. And so some years you may have a great year. No major storms, no major horrific accidents, things of that nature. And some years, boy, you just feel like you're snake bit and the claims just keep coming in. And so you got to make sure you've got that buffer to deal with the fact that you could have some really, really bad years and that you've got the adequate resources to be able to address and account for that.
Fair enough.
Follow?
Paula?
So obviously, I can tell you went to law school because you said a lot of words. But the point was, you think, yes, that it's
Yes,
a good
sir.
idea to put these kind of corridors in place. Thank
Yes,
you.
sir.
I guess I never knew a lawyer who couldn't calculate 30% of an award. Just throwing
Senator Roachford knows I disclose every time that brevity has never been identified as a strong suit for me.
Okay, I have a question, and this question is actually a go-do, okay? I don't believe that the statute would allow them to form a corporation, but assuming that they did form a corporation, in the existing law, I would like you to go consult your attorneys and figure out whether or not they would enjoy the protection from the insurance laws that they now benefit from in the way the statute is written.
Sure.
So if you would consult with them and get back to me, I would appreciate that.
I will absolutely do that, Senator. Based off of what I've heard, what I'm hearing, my assumption is that we would be looking specifically at how we could make the standards and the regs that we have on the books for financial solvency work here, and not the full range of other regulations that are in place for those entities that we do regulate. So I think we could start there, and we may be able to remain fairly narrow in that focus.
Senator.
It's sort of a two-part question. If they did come under the agency of the insurance department, would that present any risk to their nonprofit status? And secondly, since you're self-funded and you assess all the carriers that you regulate, wouldn't you have to charge a fee to these pooled trusts that would end up being passed on to the cities and towns?
So that's a very good question, and I would have to consult a couple of my legal experts on that point. This would be something a little bit different than what we traditionally regulate. Now, that's not to say that we don't have things that are a little different that we regulate. Senator Roachford was spellbound by our discussion about continuing care retirement communities a few weeks ago. How they ended up with us is not quite sure. We perhaps drew a short straw somewhere. But we do have some products and some entities that we do regulate that, again, are a little bit outside of the traditional definition of insurance. Let me take that back and figure out how we assess, and if we assess those entities as part of the department's assessment to fund what we do.
Additional questions? Thank you very much.
Thank you, Mr. Chairman. We've got the homework assignment. I'll turn that around for you as quickly as we can.
And the Secretary of State also gets a homework assignment, is to consult with the Attorney General's office over the interpretation of the statute to see whether or not they can create a corporation which absorbs the liability. So that is a major question in the things that we've been talking about. And I will be anticipating that. All right, we've got several more people here that are on the list. Remember, Senate rules don't allow you to repeat the stuff that other people have said. So if you agree with one of the groups that represents your town or whatever, just say, hey, I agree with what Health Trust said or whatever, and we'll move on quickly, I believe. Scott Dunn? You were first on the list.
How about that? Well, thank you. Good afternoon, everyone. I don't think you have...
You need the red light on.
Okay. Do that? All right. My name is Scott Dunn. I'm the town administrator for the town of Guilford. And I don't think my remarks today have been heard by you as yet. I've been a town administrator in New Hampshire for more than 30 years. I have a unique perspective on the various self-funded pools. I was around when Primex was Compensation Funds of New Hampshire and sold strictly workers' compensation insurance. I was around when PLT was primary liability coverage and went out of business, and when Health Trust was actually a division of NHMA. My perspective on this is this. All of the insurance pools should be moved out from under the Secretary of State's office and be regulated by the insurance commissioner, where the expertise level of regulating those entities far surpasses what's in the Secretary of State's office.
Any questions? Then we're good with you then.
Thank you.
Daniel Rosner?
Good afternoon, Chairman Gray and honorable members of the committee. Hearing the House rules repeated just now, please forgive me. This isn't something I've done often. So if I start to repeat anything, call me on it, please. My name is Daniel Rosner, and I am the business administrator of SAU 48 based in Plymouth. For those that are not familiar with our SAU, we comprise 9 independent school districts, making it the most complex and geographically large SAU in the state. These independent school districts include Campton, Holderness, Plymouth, Rumney, Thornton, Waterville Valley, Wentworth, and the Pemmy-Baker Regional Cooperative. I will try and be brief in my testimony as I value both your time and the time of the others testifying today. I have read both the original version and its amendment, and I am troubled by this proposed legislation. One overarching theme that comes forth is a disregard for the concept of pooling. The term risk pool inherently speaks to the sharing of risk, not each member absorbing their own. One member's group losses or gains in a specific year are sheltered from having a catastrophic effect by other members. As the laws of average play out, that support will be returned in the future. For groups that are consistently troubled or supportive, the ratings methodology of individually rating groups of more than 50 enrollees addresses this inequity. I will primarily focus my testimony on one specific component of the bill and the devastating effect it could have on our local finances. This concern is the assessment abatement issue. As you are all aware, annual budgets for a school district are adopted in March for a given year for the approaching fiscal year of July 1 to June 30th. We're going through that process right now. The primary funding of our districts comes from town collection of property taxes, which are built on the March results. Employment contracts for the coming year are distributed in the spring following the appropriation process, and that portion of our budgets that are represented by wages and benefits, typically 70 to 75%, are locked down even before the school year starts. Much of the remaining portion of our budgets, that's which are not wages and benefits, are expended during the first 2 months of the fiscal year, as the summer is the time when facilities projects are feasible and technology and other supplies are purchased for the coming year. In short, there is rarely money left over at the end of the year. If there is, it is not of any significant amount. Were the risk pools enabled to collect these funds labeled assessments or abatements? Where would these funds come from? Our budget appropriation is a firm number that cannot be amended or exceeded. Further to this, if a district were to receive an invoice for the prior year's results, where would the money come from? Would we cancel existing employment contracts or programs that have been affirmed by the voters to fund the previous year's health insurance results? School districts do not carry significant fund balances like towns do. This provision is, in my opinion, untenable. I'd just like to briefly address the capital reserve issue, as I've heard it spoken of today. The Supreme Court decision of 2014 required professional actuarial evaluations by the pools, that these be acquired in the ensuing years. Specifically, the Supreme Court dictated that reserve levels must be set with actuarially sound methodologies in consultation with qualified actuaries. I believe this is being done. The reserve levels in the proposed legislation for health pools, in particular, are significantly lower than what has been determined to be appropriate by the actuaries engaged, at least in the example of Health Trust, by far the largest of the health pools. The Supreme Court left it to the pool to choose the actuary, not the regulator. Should the levels in the proposed legislation be enacted and the pools rendered insolvent, would not the state be on the hook for the liability? This is not the case currently. Quite simply, if the member groups were forced to purchase equal benefit levels, that have been bargained for, they would be forced to pay more, if for no other reason than to support private insurers' profits and tax liabilities. This, to me, seems to be the ultimate waste of taxpayer dollars, paying local property tax dollars to an entity that would then pay over these same funds in income tax.
Questions?
Thank you.
So again, one of your concerns is on page 3, lines 3 through 5, and it talks strictly about the assessment of participating members if required after an actuarial calculation by notifying the members of a mandatory assessment due and collecting such assessments within 30 days of notice. And your discussion point is around the budgeting process of a municipality or a school district.
Not just budgeting, but cash flow, and where do these funds come from? The school districts don't have funds to pay an additional assessment. You know, we're noticed in advance. So for example, for next year, the budget that, for example, when I leave here tonight, I'm going to the Campton Annual School District meeting. Last fall, Health Trust provided the firm fixed rates, not a GMR as in past practice, but a firm fixed rate for next year. That's what the budget's built on. Hopefully the budget's approved tonight. We move forward into next fiscal year. If there are losses and we get a bill, but the budget's already spent, we don't have the cash to pay that. So I think I answered your question, but please correct me if I didn't.
Follow up.
Again, what do you do with the unexpected expense if that's not budgeted for? Normally in the process. It wouldn't be the first time you had an unbudgeted expense show up.
100%. I agree with you. So I don't mean to cut you off. Yeah, so the most common is, for example, special education expenses. Those things come up. We have to have at least a certain minimal amount of flexibility for those things. However, you know, health benefits run 10 to 14% of our total budget. So it's a much larger number. There's a much greater risk, as I see it, with that element to this bill.
Thank
you. Just a comment is because your town has entered into a self-assurance insurance agreement, you have already accepted that risk of having to pay whatever it takes for that self-insurance.
I don't know that I agree with your characterization of it. We are members in Health Trust, which...
And Health Trust is part of your risk pool, okay? Health Trust thinks that they have legally created a corporation that shields your member groups, and I disagree with that, and that's why we're going out to the legal authorities in the state to figure that out. But when you say they have given me a firm fixed price for the year, there's one word that comes to my mind, and usually I say it when I'm on the farm. And so, again, right now, the way the law is, you're part of a risk pool, and you have accepted self-insurance or requested self-insurance. So, in my opinion, you're on the hook. So, if you want to comment on that, well, fine. If not, I don't know if there's anyone else, and we'll get on to the next person. Okay. Seeing no others, Brian, professional firefighters.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Brian Rill. I'm the president of the Professional Firefighters of New Hampshire, and we represent approximately 2,000 active and retired firefighters throughout the state. I would like to thank you for the opportunity to speak today and thank the Secretary of State for bringing this forward. We are speaking in support of this bill, and I'd like to provide a slightly different perspective than what we've been hearing this afternoon. First and foremost, let me say that under the bill's analysis, I am not the subject matter expert as to what the capital adequacy reserves should be. I will not comment on those numbers. There are people far more important, far more smart that can discuss those numbers. What I want to provide as a perspective under the bill's analysis is number 3, where it talks about the standard of care, diligence, prudence, and skill in the management of the program. It was of significant concern to me recently when it came to my attention that a number of our member benefits for our covered individuals have been being cut at the foundational level for our health insurance. Our health insurance, as many of you know, for our members, all but 3 of our 43 local unions that we represent are covered by the risk pools. And those benefits are negotiated at the local level with the cities and towns. They are collectively bargained benefits, and those are benefits that are owed to us for the contributions and the rates that we pay as employees, in addition to the contributions that the political subdivisions pay. The problem we're finding now, when some of this stuff came to our attention, we started to review some public documents and found that there are these significant insolvency concerns that are before you today. And we've directly tied that through a review of minutes and meetings for the board of directors for these risk pools, and found that in part to save some money here, they have decided to cut member benefits. Some of these member benefits include some that Senator Rosenwald brought up this morning, imposing a deductible funding limit, cutting retiree benefits or changing retiree benefits, cutting anti-obesity medications, and consumer-driven programs that provide incentives to employees to shop for their health care. These programs are all negotiated benefits. And these programs and these benefits that we negotiate, we pay certain rates for. Speaking specifically to my group, we recently increased our contribution an additional 3% to acquire these benefits. And most recently, these benefits have been taken from underneath our members' feet. The problem we have here is the risk pools are made up of the political subdivisions, as we know. The political subdivisions own them, they operate them, and we're finding that when these benefits are cut by a board of directors to these risk pools, it is a circumvention of the negotiations that we have worked so hard to achieve with our cities and towns. We are hopeful that this bill will provide additional oversight and regulatory authority, and most importantly, accountability to ensure that the cities and towns, and the employees for that matter, are being charged the rates that they need to be charged for the benefits that they've earned and negotiated. Thank you.
Questions? Seeing none. Oh, Senator Waters. Got to be quoted in.
Thank you. So just to clarify on that last point, it seems like there are 2 issues. There's not only that if you negotiate through your contract that certain benefits are covered and you're paying in for that, that not only do you want to be sure that the risk pool is charging enough so that they can cover that, but also that the question of whether they have the authority to target such a benefit. So it's really 2 things. To make sure they have money to cover it, which I think the bill will take care of, but that second part, I'm not sure the bill really would take care of, except for increasing transparency about letting you know something's being done. But I'm not sure whether the bill do you see the bill as having any protection for negotiated contractual benefits that must be respected by the risk pool?
Sure. Thank you for the question. Unfortunately, I don't. The answer to your first question is I do believe it ensures that the money is available to pay the claims and claims-related expenses, which I think will have a downstream effect that our benefits will not be cut from underneath us. Unfortunately, I think the problem that we're finding is unrelated to this bill and this committee, but a lot of this stuff is going to have to be discussed at the local level, because I think what is happening is by virtue of the practices of the risk pools and cutting these benefits, the cities and towns are then saying, unfortunately, there's nothing we can do. The risk pools have cut these benefits. And so they're absolving themselves of their responsibility, even though they still have a governmental responsibility to follow other laws.
Thank you.
Additional questions? Seeing none. Michael Cranes? Okay. Michael will correct me when he comes up.
Right.
I are an engineer. We're not noted for our spelling, grammar, all that stuff.
Michael Cryans. I'm on the board of NHIT, and I hope I don't become redundant when I talk about the assessment and the replenishment. For 19 years, I was a county commissioner, and I know how difficult it is to put together a budget. And any of you that have served as a legislator at the House level know that it goes through that process. And most typically, there's not a lot of money left over because even where we start, it seems to get trimmed down a little more. I also had the privilege of serving on the Executive Council for 2 years, and I had 103 towns in 4 cities. And some of the towns were very, very small. And I don't know how you come up with the replenishment or the assessment. That's my big concern is I have no magical answer, but I know that there's a variety of different times when budgets are passed within communities, and to all of a sudden, especially some of the smaller communities, to present them with a large bill, because we know in most cases it's pretty simple math. It's your personnel cost, either your payroll or your insurance. I mean, that's a big portion of your county, of your town or county or school budgets. So very briefly, I hope you will at least consider the impact that it will have on a lot of these small communities. And that's about all I have to offer.
All right, questions? Seeing none, thank you very much.
Thank you. Oh, it's Mardi Gras. That's how you guys spend the day?
Yeah, let the good times roll. Okay. Kate? If I remembered how to do it, I would have said it in French, but, you know.
Thank you, Mr. Chairman and members of the committee. My name is Kate Horgan. I'm here on behalf of the New Hampshire Association of Counties, and I am pinch hitting for Kathy Stacy today, who is still down at the National Association conference, but we'll be back tomorrow. So if you have any questions, I can take them back to her. The association is in opposition to the bill. For a variety of reasons, counties, cannot technically find reasonable rates through the commercial insurance. We do some of the most litigated work in counties. We do nursing homes, we do jails. We get sued all the time, right? So oftentimes we have to use risk pools as the only option that we have out there. We're really concerned around the 30-day deadline, as former Commissioner Cryans just mentioned, now Treasurer Cryans, on the replenishment funds, and just how that would be handled for county budgets. We would recommend that this bill came up really quick. It's extremely complicated. You should it would be our recommendation to retain this bill and work on it with all of the stakeholders and move forward. I can try and take questions, but most questions I'll have to take back to Register Stacy. But happy to take any I can come up with.
Questions? Senator Waters.
Thank you, Mr. Chairman. So would it be fair to say in looking at this that essentially the bill does give you to 2028, and in the hopes that between now and then there isn't some kind of emergency? Of course, there could be. So if you have the 2028, might it make sense to have some rulemaking capacity for getting at what might happen if there is that assessment? And that would be the rulemaking might be the opportunity, if we pass something, for you all to work that out in the case that contingency does come up.
Thank you for the question, Senator. Rulemaking is always helpful. It's not currently in the bill. We would always love to have it. It makes things clearer for everyone involved. I hope that answers your question.
Yeah, and I think just to maybe have you take a look at this, that I think that the idea would be to have the Bureau of Securities Regulation make rules for 5B, 4-B and 5B, 5I, Roman 1, parentheses I, parentheses 3, and that those would be the two sections of this where rulemaking might affect you all.
I'm happy to take that back to
Thank you.
Register Stacy and get her feedback and get that to the committee as quickly as possible.
And I think the Secretary of State's representative copied down those comments also.
Sorry?
I think you copied down those comments also. Okay. Further questions? Seeing none, thank you very much.
Thank you.
Scott Gross?
You want to drop that last one?
One more. No.
Scott Gross, Goffstown, New Hampshire. I'm a business administrator for SAU 19, and I never thought that I would ever say that I've worked 30 years in the insurance business before I did that, so I'm pleasantly surprised to hear about actuarial studies. I want to provide a little bit of additional perspective. I too am against this bill solely because I think it's moving way too fast. It kind of disheartened me to hear that people got this, including the insurance commissioner, some of these agencies, they got this like a week ago. This is a pretty heavy and very complicated topic, and to think that this is moving this rapidly is a bit concerning. That said, I do believe in solvency. Obviously, I worked for an insurance company for 30 years. Solvency is the most important thing. But I wanted to share a couple of things. One, I do believe that that narrow band corridor, whatever we called it, is a little bit too narrow. And I wanted to share with you what you probably have not heard yet. But when we did receive those surplus funds back from our pool in 2 consecutive years, the amount of time that it takes for a business office to process those reimbursements is days. Because not only is it the reimbursement or the surplus that has to go back to the town, but you may not know this, it also has to go back to all of the individual members, all of those employees, retirees who may have paid premiums. Many of these people we might not even have addresses for. Some we do have addresses for. So you process checks for anywhere from $18 upwards of $400 and something, checks that don't get cashed. Then we get into the lovely world of abandoned property with the state of New Hampshire. That's not a fun experience either. So there is a cost to this. And I would say that if there is to error on the side of anything, I am all for the minimums, all for solvency. That should be actuarially based. But if you're going to error on the side, have a higher or a wider band, simply because it is not always the best thing to do to return some of these surpluses. So as was provided before in testimony, we received 2 years straight where we had surpluses and we had to spend the days upon days of returning them. And then the following year, we had a double-digit increase. So again, I'm not privy to actions of these pools and their board of directors, et cetera. But the one thing that I said to my HR director who's sitting behind me is I said, man, why did they do this? They should have just held on to this. This was common sense. We just came out of a pandemic. Everybody knew that we were putting off these things and that you'd have a surge afterwards. And again, I'm not privy to these board of directors meetings, but to me, the notion of returning the money, that did not make sense. Lastly, I will leave you with this. In the private sector, there are pensions, and we've all heard of the woes of pensions, private pensions and pensions going insolvent, and there's regulations with regard to that. There is the Pension Benefit Guarantee Fund, and that is another tool, not that particular fund, it's not a tool at your disposal, but a state guarantee fund, which no one has mentioned, where that would be a potential backstop in case there was a problem for solvency for any of these risk pools. So that's why I think this thing is moving a bit too quickly. There are other options here. And that's why I think you need some more time to kind of work with the stakeholders and study this a bit more. But it's all noble, it's all good. Everything that has been discussed, I totally get it. That's it.
I have a question.
Sure.
What is the option when the actuary for the state of New Hampshire says that there is two funds that are in risk of becoming insolvent by the end of this year? What is my other option than to push this thing through?
So as you jokingly said, Mr. Chair, about attorneys, et cetera, you should note, and I've been around actuaries for 30 years in my prior job, they have different opinions. And that is no disrespect to the gentleman that testified earlier. I am sure that he is a fellow of actuarial science, et cetera. I get that. But they do have different opinions. And sometimes another actuarial opinion from the state is not a bad idea on such a pretty heavy thing. I get that there's going to be disputes, and I'm not saying anything ill or challenging the qualifications of the state's expert who's an actuary, but they do have different opinions. So that's another thing why I think this is moving too fast. You could get another actuarial firm to review the analysis, and again, you're more information the better. But I hear what you're saying in the sense that you're hearing about insolvency and you got to act quickly, but you know, getting another opinion is not a bad idea. You would if it was a medical procedure and other things. That's all I'm saying.
Not to debate this, but in the report where we showed what was going on, there was nobody that's, you know, the report that would go out to 2028, okay, and we show very, very minor changes that would happen because of these changes in the law. And again, you know, but that's when you take action. And I know that Health Trust has taken some action and going to do things. And that's why their numbers at 2028 look good. I'm not so sure about NHIT and where they're looking. And when I look at the red on their chart compared to the others, what other options are open to me?
You asking me my opinion?
You're the one that said I had options, and I'm
Well,
asking for what that option is.
What I'm trying to say is, well, one, you should be asking, why are you finding out about this now? Why have you not found out about this a year ago or 18 months ago? Because these issues were very well known in terms of post-COVID financial implications. So you are getting this now, but the bigger question is, why didn't you get it 18 months ago? Why was your hand forced in this committee to take immediate action and to file a bill late?
And if that answer is because we asked those risk pools to take action and they did not, and now we are in extremis.
Again, Mr. Chair, respectfully, from what I heard from the members that testified, their boards of directors did meet. They did take some corrective actions. There is a respectful disagreement between the state's expert actuary and those of the firms that were hired by the risk pools, and I think that is an issue. There's no doubt about it. But I think in this particular case, you know, sometimes when you look at data or actuarials look at data and they have a discussion, and I don't know if that took place. I honestly don't. I was not privy to that. But when people sit down and they discuss the data and how they arrive at those models or those assumptions, you can get to the bottom line of that. I just don't know if that occurred, sir.
And Senator Lang.
I'm just going to ask the same question I was asking about other members is, do you agree that is that putting some sort of corridor in statute is protective of the municipalities, and we should have something? We can argue whether it's 12 or 20%, but it's somewhere in that range.
There's no doubt that there needs to be minimum expectations. I think, you know, my particular issue is, what should that maximum be? And I don't know the answer to that, and I'm not nearly qualified as the expert here or others in this room as to what that high end should be. But having regulations to ensure the solvency of these risk pools is critically important. My other big takeaway from this whole hearing was the fact that the insurance department commissioner was here. I do believe that that is something that they have a lot of expertise in. And I'm not saying that the Secretary of State's office doesn't, but it is in at least the swim lane of the insurance department.
Okay, thank you.
Any additional questions? Thank you.
Thank you.
Last one on the list is Glenn. Glenn Brackett.
He's not here.
He left a bit ago. All right. You can look in the hallway. All right, that's the last one that I have on my list. Somewhere down here, I've got the numbers from the online sign-in.
That we see, Mr. Chair.
Okay. The numbers of people signed in and support was? 3. And the number opposed was? 47. Okay. And with that, I will adjourn the Election Law and Municipal Affairs Committee. Question for the finance people. It's now almost 4 o'clock, so I don't really want to take up any other finance bills. But if the members of the committee wanted to, they could state their case. Seeing no one interested, our business of the day being complete, the Finance Committee is adjourned.
Well done, Mr.